Okay. So this is case number 2401653 GC Calvary SPV1 LLC versus Tarina, Tarena Ingram.
Good afternoon, Your Honor. Jeff Warber, P67124 on behalf of.
All right, Mr. Weber, good afternoon. Ma'am, what is your name?
Hello, Your Honor, Tarina Ingram.
All right.
Thank
And
you.
good afternoon to you.
Good afternoon, and thank you for hearing this case.
Well, no problem. We have to do that. All right. And so today, from my understanding, I don't have a separate, submission with respect to this matter. It's my understanding that this is a Judge Arvant case and that there was a ruling on a motion to disqualify the judge, and she denied it for some reasons that she stated on the record. So I don't have a transcript of that. But you've asked me as chief judge to review the whole situation, pretty much de novo, as to whether or not Judge Arvant should be, in fact, recused from the case. So what is your basis that you're claiming that she should be recused from the case?
My basis is I compelled the motion, the date of the deposition, to compel to arbitration per the credit card agreement. I stated that I could compel arbitration at any time as long as there wasn't a default judgment or a trial started.
Okay.
So I did.
So this was a credit card debt.
Yes.
With the plaintiff, Calvary SPV now. And you're
Okay.
saying that whatever the agreement was on the underlying debt involved an arbitration agreement.
Yes.
And you're saying that that agreement specifically said that you could request it at any point in time.
Yes.
Okay, so what is the basis for the recusal of the judge?
She denied the motion
Okay.
and entered a default judgment.
Before we even get into the legal weeds of this case, let's be clear about what you are about to witness. This is not a story about injustice, corruption, or a rogue judge. This is a masterclass in what happens when someone confuses losing a case with judicial bias. The defendant here isn't challenging evidence, procedure, or the law in any meaningful way. Instead, she's attempting one of the most common courtroom Hail Marys, trying to remove a judge simply because she didn't like the outcome. And what makes this fascinating is how calmly, methodically, and decisively the chief judge dismantles that argument piece by piece. This hearing isn't about relitigating the debt. It's not about arbitration anymore. It's about whether a judge should be disqualified for doing her job. And as you'll see, the legal standard for recusal is extremely high, much higher than hurt feelings or frustration. Pay close attention, because this case perfectly exposes the difference between actual bias and perceived unfairness, something many litigants get wrong.
So now you do know that there is a specific rule that outlines when a judge can be disqualified. So you're going to have to meet the standard under that rule. Now, typically, if a judge just takes an action on a case and you don't like it, that's an appealable issue to the higher court if you wanted to do that. But I'm not sure that that means that she should be removed. You have to meet the standard for disqualification. So
Okay.
what other than her ruling, what is it?
Well, it was unjust, and this
Lawyer?
lawyer attorney violated a lot of my rights. The debt was only $1,877. I never denied the debt, but this attorney never served me the original summons. Never served me.
Okay, but I can't, no, let me tell you what I can't do.
Okay.
What I can't do, because Judge Arvant is in charge of her rulings on
Yes.
her case. So I can't go back and change her ruling on the
Yes.
facts or the law. What I can do is decide if there was anything in the circumstances of what she did that would point to a reason to have her removed from the case.
She showed favoritism to the attorney from the
And how
beginning
was-
of the case.
How was that?
She made biased statements,
Such as?
such as when I told her that I mentioned that I never received the original summons, she said it didn't matter. You were put on notice with the alternative order that I signed.
Was that alternative service?
Yeah, yeah,
So what we call alternate
or a
service?
second summons or alternate summons.
Oh,
Alternative order or,
so it sounds like you're saying that she's basically saying if you didn't personally have it, that alternate service would satisfy it. So that's a court ruling. How does that show bias?
it's just statements that she made. She didn't, everything that I said, she didn't hold him accountable for anything. She didn't ask him anything. Well, what steps did you take to serve her? She just showed him favor. He told her, he said that, Your Honor, you know me. I've been in your court before. He made oppressive statements, and during the mediation on the Zoom video, the judge is going to enter default judgment against you. He said it several times, like threatening and abusive and oppressive statements.
Okay, that's what he did though.
Yes.
So here's the thing. The rule really sets out the kinds of things that the judge has to do. This is a pretty high standard to get somebody removed. And I understand you might not like the way she ruled on something. And it could be the case that you don't understand how she applied the law on some things. Because I will say this, and I'm not commenting on the validity of her ruling, but I can tell you that alternate service is usually given by court order when someone has had trouble personally serving. And so that is considered good service under the court rules.
Yes.
So I don't know if there was something wrong with her ruling there, but I can just tell you that that pretty much is normal. And if you're following the rules, if the judge is doing that and you don't like it, the real remedy is to appeal it and see, not to me, because I'm not a judge, but appeal it to the next higher court if you think that there's something legally wrong with what she did.
Right.
Because, you know, for this, you have to have real specific facts of how the judge would be biased or prejudiced. What is it she actually did other than just ruling on the motions or ruling on your requests or saying things like, well, it doesn't matter because you got alternate service. That's not a bias. That's really stating what the law says.
Right.
So you have to have a really good reason to show bias.
But it was my third motion, the third one. She already listened to the disqualified one and she denied that.
Right, and that's what you're appealing to me, is her denial of that.
I'm appealing the default judgment.
This right here is where the defendant's entire argument starts to crumble. The chief judge makes something very clear that a lot of people, especially self-represented litigants, don't fully understand. Judges are not referees whose calls can be overturned just because one side is unhappy. If simply denying a motion were grounds for recusal, the court system would collapse overnight. Every ruling produces a winner and a loser. The law assumes judges will rule against someone. That's literally their job. Recusal requires proof of actual bias, personal interest, or conduct that shows the judge cannot be fair. Not disagreement, not disappointment, not even anger. The defendant keeps circling back to it was unjust, but unjust to whom? And under what rule? Courts don't operate on feelings. They operate on standards. And right now, she hasn't even come close to meeting one.
I can't do that. You have to go to circuit court to appeal her ruling on the set aside law. The only thing I can do is say whether she should have removed herself or not. That's the only thing I can do because I'm not sitting as an appellate judge. The appellate judges are at the Oakland County Circuit Court. So you could have done one of two things. Probably you could have asked her to reconsider her ruling. And if there's nothing new you're presenting, then she may not reconsider it. The ruling might be the same. Or you could, within the time frame that's allowed under the court rules, you could file an appeal up to the circuit court. And they would have to look at it and see if she did something wrong I guess, ruling on that
She
motion.
overlooked my complaints of the attorney violating my rights, my civil rights, and as a consumer, she overlooked that. She didn't look into that at all. She just overlooked it and just reprimanded me. She overlooked my rights being violated.
Okay, well, what rights were violated that caused her, that is showing some kind of bias?
Improper service. She didn't look into anything. The documents,
So we just went over the service part.
Well,
Alternate service
and then
might be good.
the oppressing statements that he made during the mediation, to me, that's a violation of the Federal Credit Consumers Act, that a debt collector or whoever's not supposed to make oppressive, abusive statements to collect the debt. He said it several times.
Well, okay, so I don't know what you asked her to do because I have no transcript. No one has given me a transcript of what actually occurred. And I'm really hearing this de novo, which means from the beginning, as if you never did it over there with Judge Arvin. So I'm trying to understand, what is it? Now, let's just say he did what you said, and he said some oppressive statements to you. What about that causes the judge to have to remove herself from the case because he made these statements to you in a mediation? Which, and let me just say this, normally, whatever's done at mediation, we don't know anyway. We don't really get involved with these.
Okay.
That's called a settlement process.
Okay,
So we usually don't even know what happened at the mediation, and what, if there was an offer or not, and where they were, or how far the parties were apart, you know, what you offered them, what they said they would accept or wouldn't accept. We don't really know that because that's a settlement negotiation tool. But if you're saying he said something that you thought was offensive, what was it that you asked the judge to do? What was she supposed to do? And how does that show she was biased against you or prejudiced against you? Because it's a very high standard. What you're asking me to do is remove her from that case and have it reassigned to some other judge.
okay,
And that's the only thing I can do. I can't look at whether she was correct in her ruling on something because that's an appellate.
okay,
That's an appellate issue. But I can say if something she did seemed like it was rises to that level of bias or prejudice against you, then I would say that motion, if you're asking for her to recuse herself, then that should be granted. And then I would have it reassigned to someone else. Either myself, it's a blind draw, myself or the other judge could possibly get it. But you would have to meet that standard just on that. So unless she said or did something that shows bias, we can't worry about the actual ruling itself.
okay.
If you understand the difference.
Yes, I do, yes. She made a few statements. I mean, this happened a few months back. I can't recall everything, but I did write some things down. Like I said, she was showing bias favor towards him when he told her, "You know me, Judge." And she made a comment about, well, some people just don't like to be served. I think that was biased. That wasn't just for her to say that because he never served me. So she was automatically.
When you say serve, you mean personally?
The summons, yes.
Yeah.
And she said, well, some people just don't like to be served.
Here's where we see a classic courtroom misconception play out in real time. The defendant believes that because the judge explained the law, specifically alternate service, that explanation somehow proves favoritism. But explaining the law isn't bias. It's literally the judge's role. Alternate service exists precisely because people can't always be personally served. Courts authorize it, rely on it, and uphold it every single day. When the judge says that's sufficient notice, she isn't siding with the plaintiff. She's applying established legal rules. The problem here isn't prejudice, it's misunderstanding. And misunderstanding the law doesn't invalidate it. This is the moment where the emotional argument starts replacing the legal one. And once that happens, the chances of success drop dramatically.
Well, how's that bias though? That's just a fact that is actually accurate. There are people that what we call evade service.
Right.
And if people evade service, then they can come back and ask the court for an order of alternate service, meaning that you don't have to hand it directly to them.
Right.
But you
tack it
do.
on the door or something.
Yeah, you have to tack it. You have to do it certified mail and first class mail. Do things that would be reasonably calculated to get a person notice of a lawsuit.
And he didn't do any of that. He didn't do any of that, and that's what I'm saying. She didn't listen to me, period. She didn't look into anything. He didn't do any of that.
So you believe she was expressing a bias because she didn't look into
the case, the details,
and the details of the service.
Of me. Yeah, so what I'm claiming, I showed up, what I'm saying. She didn't look at anything.
So,
He didn't do any of that.
Well-
He didn't do anything. He just was deceptive and did all these tactics that he's not supposed to do, and he got away with it. And she empowers that. It's an article that I submitted to her about these debt collectors buying debts less than $2,000 for pennies on the dollar, and they're targeting minority and black, predominantly black communities. There's a justice report.
okay, well, what would you like her to have done with the article and the fact that
I would have liked
They
for her
might be,
to
quote,
look into
targeting
it
blacks
and listen, give me a chance and be just and fair, and not look at me and treat me like I'm a criminal because I experienced some financial hardship. I paid my bills. I had 11 credit cards that went bad. I paid them all. I'm down to 4. She didn't give me an opportunity to express and state my claims and show proof. She just reprimanded me, and she directly favored him and gave him the green light to do what he's doing. He never served me. He then he went for a gun.
Didn't we just say though that she ruled on the service and said that there was alternate service, so she didn't have to serve you?
And
They didn't have to serve you
Right.
personally.
but he didn't
That's
serve me at
something-
all. He didn't serve
Well,
me.
you don't think
period.
you got it served any other way? It wasn't tagged, it wasn't sent by mail, it was nothing.
No.
There was no certificate, there was nothing.
No.
And wait a minute, hold on, Ms. Werner, I'm gonna get right to you in a minute. So normally, the judges would look in the file
Right.
and it will show how it was served.
Right.
You're saying this case showed nothing?
No.
Okay.
And there was a few documents that some server documented that they came out to my home
Well, that's what we
3
looked at.
times, 2 times.
This section is especially important because it highlights a crucial legal distinction. Even if everything the defendant says about the attorney's behavior were true, threatening language, aggressive negotiation, or pressure during mediation, that still does not automatically translate into judicial bias. Attorneys are advocates. They push. Judges are neutral arbiters. Unless the judge participates in or endorses that conduct, it doesn't meet the threshold for recusal. Mediation itself is confidential and intentionally insulated from judicial review for this exact reason. Courts don't punish judges for what lawyers say behind closed doors. And the chief judge is laser focused here, repeatedly pulling the conversation back to one question. What did the judge herself do that proves bias? So far, there's no answer.
I was at work. They were work hours. I worked 9 to 5. 2 of those times was work hours. And then the third time, I don't know, I think it was on a Sunday or something, and I'm home. I'm out walking my dog, I'm sitting on the front porch. But the 2 times it was documented that, because I looked at the register, it's called register or something. I came up here. It's called register and accident or something.
Yeah.
Yes. And 2 of the documents that the young lady documented saying the windows was up, the lights was on. This was in May. And I was at work both of those times. I worked 9 to 5. I was working in Redford. I work in outpatient. I'm a registered nurse. And I
So
work,
you believe that she should have held a hearing? As
yes,
to whether or not the service
Was-
document was accurate?
yes.
Okay, well, if she didn't, how does that show bias? That means maybe she was wrong in what she did procedurally, and that's an appellate issue. How does it show bias? I have to get to actual biases. Almost, not totally, very difficult, if not impossible
Yeah.
to show. You have to have a lot more than what you're saying, which is, her rulings on the particular case.
She favored him.
Okay.
And the article stated that these debt collectors are buying debts and targeting black communities and minorities versus middle class communities. They're targeting the black communities and minorities.
Okay, and you know what? Maybe that's true, but how does that mean I should recuse the judge because she didn't look at the article?
But isn't that her job?
To look at your article? No,
No, to look at the case.
Yeah, she has to look at the case for sure. But the question is, if you wanted her to look at an article about how the debt collectors are
She
targeted.
said I asked her, did she look at it? She did, yeah, I seen it, and she did, and that's fine, she didn't elaborate. But
Okay.
she didn't look at the case and ask more, information from them. They never served me, Your Honor. They
Okay.
never served me.
I understand what you're saying, but that's an issue I can't deal with. I can't go back and change her ruling
Mhm.
on the issue. All I can do is look and see if whatever she did was bias or prejudice.
It was, she
Well,
was,
that's what you say. I read
right,
it.
and she made a comment to the Zoom, there was a Zoom hearing going on before my case.
Because I,
She referenced me to that, Zoom hearing, whoever case that was, she made a reference to me, comparing me to that. I didn't elaborate because she was already frustrated with me.
This is where the chief judge essentially draws a bright red line that the defendant keeps trying to cross. An appeal and a recusal are not interchangeable tools. Appeals challenge legal correctness. Recusals challenge judicial impartiality. Mixing those up is fatal to a case like this. The defendant wants the chief judge to undo rulings, revisit evidence, and punish alleged attorney misconduct. But that's not what this courtroom is for. This hearing has one narrow purpose: determine whether the original judge should have stepped aside. And the chief judge repeatedly explains that she is not an appellate court. That distinction matters because courts are structured hierarchically for a reason. Skip the process, and you lose credibility instantly.
But she referenced me, and on that meeting, it was a black couple, and it was a Caucasian attorney. That's the only thing that I've seen maybe that was in common. But she referenced, and that's not right. She's not. I mean, I don't think that's lawful for her to even do that. She made a reference to the Zoom.
Remember, I'm not looking at lawfulness per se. I'm looking as to whatever. See, you haven't given me any specific. I'm just hearing all this for the first time.
Right.
There's no brief, there's no motion. So I'm just hearing, you're telling me she said this, she did that, without me actually seeing what it was.
Well, can you look into it?
Claim that she said. It doesn't, it's everything to me sounds like she's just ruling on a case, and I'm gonna let him respond back to
Okay.
what you're saying now, and we'll go from there. Go ahead, what do you want to say?
This matter is simply about following the court.
Well, that's what I'm trying to explain to her.
Exactly.
Before you even start, I'm not trying to side with him. I was trying to tell you earlier that you have to follow what the rules say.
Yes.
And if she did or didn't follow those court rules properly, that's in a case for an appeal. And it wouldn't necessarily be that she's biased against you and for him. That's just a ruling. And unfortunately, in this job, we got to rule against somebody one way or the other.
I understand.
But if it's just a matter of court rules, I'm hearing, that's why I was telling you earlier, I'm hearing more of it. Sounds like she was just applying the rule on alternate service. Now, if you think you should have had a hearing on it, because she gets a chance to rely on what the process server said. But if you bring proof showing that what the process server said couldn't possibly